are confusingly similar or very similar, whose job is it to prove that the goods and services of one mark holder and the other mark holder are in the same industry? I'm Angela Langlotz, and I go live here on weekdays to talk about trademark and copyright law. And I'm going to answer this question from a viewer yesterday. He said, Angela, how do you prove that these goods are related when there is a likelihood of confusion that is alleged? Now, remember, marks are similar. If the marks are similar, then we look at whether or not the new mark, that we call that the junior mark, and the senior mark, if they're related, if they're identical or very, very similar, then we look at a likelihood of confusion. Now, keep in mind, we don't have to prove actual consumer confusion, only a likelihood of confusion. And that likelihood of confusion will arise when we have the goods from the junior user and the goods or services of the senior user somehow being either identical or related. So how do we prove what's related and what's not? Well, we go out into the marketplace and we have a look. Now, in the context of someone, the senior user, accusing the junior user of a trademark infringement, usually the senior user in their initial pleading in court would say something like, hey, here is the proof, right? We offer the proof in that initial filing that the junior user and the senior user, our goods are related, okay? And that could be just going out into the marketplace and having a look and seeing who exactly is producing what goods. If the context of the confusingly similar allegation is that we have a junior user who has applied for a trademark and the trademark application is before the trademark examiner, then the trademark examiner will issue a refusal based on, if it's appropriate, based on a likelihood of confusion. And she will put into the office action rejecting the trademark proof that the junior user, the goods of the junior user and the goods of the senior user are commonly produced by the same company. So if there's a common source in the marketplace for those sorts of goods, then there is a likelihood that consumers are going to be confused when confronted with the junior mark and the senior mark in the marketplace. And for that reason, the mark will be refused. Now, these sorts of rejections, yes, they can be overcome, and sometimes the trademark examiners are a little overzealous. And that's why you hire somebody like me to shepherd your trademark application through the process, because that's a pretty common rejection that is cited by the trademark examiner because the trademark database is very, very crowded these days. So that is the answer to the question of who has to prove whether or not the goods and services are related. I'm Angela Langlotz, and I go live here weekdays to talk about trademark and copyright law. You can find me online at TrademarkDoctor.net. If you'd like to know every time I go live, you can either like my Facebook page or subscribe to my YouTube channel. I'll see you later.